Hi.
Hi, Vishti, how are you?
I'm very well. How about you?
Great. You are sitting in London, or that's only the background?
Well, actually, that's background at in the U.S. It's St. Louis.
Oh, okay.
Good
So,
evening,
Vishti,
everyone. Welcome to the NHRDN Mumbai Chapter webinar. Uh, we will start the program with NHRDN Code of Conduct. My colleague Kavita will read the Code of Conduct for all of us. I will request everyone to be on silent, and post that we will start with the session. I'll welcome Kavita. Good evening, everyone. So I'll read the NHRDN Code of Conduct. I will always strive to meet the highest evolving standards of competence in the profession and add value to organizational success. I will deal with all stakeholders with utmost integrity and create an environment of trust leading to ethical success of my organization. I will ensure that I am always reliable and consistent in all my actions by accepting responsibilities for my decisions and actions, thereby creating credibility for my profession and myself. I will be objective in all my actions and decisions and foster fairness with firmness. I will conduct myself in a way that facilitates growth and development of all those I am responsible for. I will strive to be a role model for all others and champion exemplary practice of the HR profession. I will respect I will respect with the rights of privacy, will not use my position for personal gains, and ensure that there is no conflict of interest in what I do with any of my stakeholders. Thank you. Thank you, Kavita. Now I would request Professor Vijayan Pankajakshan to introduce Rajan sir.
Yeah, can we start? So good afternoon. It's a proud privilege and honor for me to introduce the speaker of the day, none other than Dr. Rajan Mehrotra. He's much senior to me, and I remember in TISs while studying, we used to hear some of his, I would say, transformational practices in one of the companies. And those days, it was the days of very strong union power. And I think those were the turning points when we learned how to engage in constructive cooperation with various stakeholders, including the union. Dr. Rajan Mehrotra is the former senior employers specialist for the South Asian region with the International Labour Organization. As you all know, is the global standards, is the global trend setter for employee relations, and also the former corporate head of HR with the large cement company ACC Limited. He is also former corporate head of manufacturing and HR, which itself is a distinction, and an independent director on the board of the Swiss multinational. Then it used to be called Sandoz, now it's called Novartis, for 20 years from 2000 to 2020. Dr. Rajan Mehrotra continues to maintain close links by giving back enormous quantities of knowledge, guidance, and inspiration to the academic world as a visiting faculty, including some of the IIMs from 2013. On behalf of Mumbai Chapter of NHRDN and Central Office of NHRDN, it's my privilege to welcome Dr. Rajan Mehrotra. Over to you, sir.
Thank you, Professor Vijayan, and
Can
good
you pray?
afternoon, everybody. It's a pleasure interacting with all of you all and sharing my experience. I'll straight move to the PowerPoint. I'm going to deal with the impact of labor code on business and IR, both from an organizational and a professional perspective. And to begin with, let me take up that what has been the background, how things are changing, and what do we expect at the moment. What are the benefits as well as the limitations of the new code and how they will impact industry. When I look at the background, the Second National Commission on Labor was set up on 15th October 1999 under the chairmanship of Mr. Ravin Verma, and he was primarily assigned two tasks. One was rationalization of existing laws relating to the organized sector, and the other was with reference to the unorganized sector. I had chance to closely interact with him because I was working with the ILO at that time. And I do recollect, that his terms of reference permitted to present an interim report. Since I was closely interacting with him, I once told him that, sir, why don't you present an interim report? Because I recollect the first National Commission on Labor report was published in 1969 when I was a student. Chief Justice, ex-Chief Justice P.B. Gajendra Gadkar, who was those days the Vice Chancellor of Bombay University when I was a student, submitted the report. I recollect buying a copy of it for 10 rupees, and it never saw the light of the day. And I did tell him, that all these reports do take time to implement. And since your terms of reference compared to the previous terms of reference do permit an interim report, my suggestion would be, I come from the corporate sector, that do submit an interim report and it will know whether the government implements or not. He never replied to that question. Obviously, there must be limitation. And he did not submit an interim report, though I must admit that he did submit the final report both for the organized as well as the unorganized sector on 29 June 2002. Now, we are today in 2024, which is 22 years since this report was submitted. Though water has flowed, things have happened. Let's try and look at it. He had recommended that you have, as far as the organized sector is concerned, 5 groupings in terms of laws: wages, social security, safety, welfare and working, and industrial relations. What has happened that the government, in its own wisdom, decided to have 4, and they combined occupational safety, health and working condition as a combined code, which then makes it quite complicated for 2 reasons. That when you look at occupational safety, health, it is predominantly prevalent with reference to the factories, mines and plantation. But once you cover everything, the definition had to change. It became establishment and gets applicable. Well, in all the wisdom, the present government decided instead of 5 to have 4, and hence 4 labor codes got passed by Parliament, which all of us are well conversant that the first code on wages was passed in 2019, and the balance 3 codes, the Social Security Code, Occupational Safety, Health and Working Condition Code, and the IR code were passed in 2020 when we were during the period of COVID in September. There have been various debates, discussions about these codes. When these were passed by Parliament, and Mr. Gangawar was the Labour Minister, he himself said that he'll make it operational on 1st April 2021, because these got the assent the next day from the then President. And the rules had not been made, but the draft rules were made available. Later, he indicated that it will be 1st October 2021. Then Mr. Gangewar, the new Labour Minister, came, Mr. Yadav. The government has changed. And presently, when I was to speak on this webinar, I know some people that are attending, few of them telephoned me, Rajan, they said, has it not gone in cold storage? I said, well, this has not gone in cold storage because this was one of the items to be implemented by the NDA-led government, by BJP, in the first 100 days. Well, it is not taking place in the first 100 days, but when I followed up with the Ministry of Labor, they consciously are trying to have meetings regional wise with the employer organizations as well as the trade unions in South, North, West, East, Northeast, all that over a period of the 3 months. It has already started in this month. In fact, yesterday, one of the meetings started, and they're hopeful that they would be able to implement this by beginning of 2025. And that's why I have said that this would be in the near future implemented. The rules, when you look at it, one needs to understand that passing the act by parliament is one part, but the rules become essential because labor being a concurrent subject under the constitution, you have both central and state government rules. I did try to collect what is the present status of the rules in order to speak for this webinar. And I must admit that as far as the central and state governments are concerned, the draft rules have been framed except in the states of Meghalaya, Nagaland, and West Bengal. West Bengal is a major state that has not done it. And in the union territories, it's primarily Delhi. But otherwise, Nicobar Island, it's small, Dadra, Nagar, Haveli, Daman, Diu, Lakshadweep. So the final rules have not been released because the central government, I understand, is ready but have not released. So I will briefly look at some of the draft rules, but there can be some changes, but invariably not much change take place. So I just thought that I'll bring out that the status today with reference to the rules is fairly good. Now it's a question of when the central government releases the rules, because then through a gazette notification, they'll have to make that these laws become operational. When I look in terms of the code, and from a business perspective and IR, from an organizational and a professional angle, I would look at business of all phases when you look at laws, labor laws. You have businesses that are very young, which is a greenfield site. Now, greenfield site, I may have very little people, but on a greenfield site, I have a choice of the manpower that I choose. And a lot of service sector industries which have grown post 1991, their manning norms are very different from those companies that are pre-1991. I had in my career occasion to work 21 years before 1991, before the Indian economy opened up. And I had exactly 21 years to work after the Indian economy opened up. Okay, I worked with all companies that were born in pre-independence era, so they have inherited legacies. But there is businesses which are of the starting phase and the laws also apply to them. Then in a business, you have a growth when you are able to take care, expand. You are on a growth trajectory. But it's also true that you get in terms of brownfield sites which are stagnant. And there are businesses that are on the decline and get wiped out. Let's be clear with technological development, how businesses go through restructuring. And I have myself gone through phases of restructuring when you have to look in terms of a decline phase. If you can turn it around, then it remains. And there are companies that become sick. And when you are sick, quite often you have to learn to live in coma because the present laws would not permit you to die. And death was not easy for companies because the government would not grant you permission. Though in all fairness, I must admit that Mr. Arun Jaitley, as the finance minister, did bring in the bankruptcy code which has given. Otherwise, it had to go through SICCA. And there was a time when SICC companies used to be nationalized by the government taking them over. But that phase has gone. Post 1991, that is not a phase. All of us who live in the city of Mumbai, you can clearly see Richardson Kudas 1972 when you go on the JJ Hospital flyover. Richardson Kudas was a leading engineering company prior to Larsen Toubro. In fact, if one looks in terms of the structures that they have made, are one of the finest ones. If you look at the Bombay Central Station and look at the arch, it's a riveted structure which is unbelievable in terms of what. But these are sick companies. they get nationalized and they're virtually closed down. So businesses have to go through various phases. When you look at the law of the land will remain. The law does not specify, labor laws are not different for various types of companies in terms of their phases. But businesses will go through phases. They will go through mergers, acquisitions. There will be bifurcations of business that will take place. And from that angle, I want to look at it that what really happens when you look both from an organizational, professional perspective. And I will now concentrate primarily in the area of industrial relations, which impacts all these businesses. Now, what has happened? The business model and the workforce composition model of present enterprises is very different from the pre-1991 model. The business model is have limited assets, improve revenue and profitability. So as the supply chain management in India has grown, you can see how the businesses have grown in terms of, you can see the platform workers growth. All those are points which I will deal later. But clearly the business model is not what it was earlier. It is not integrated manufacturing. It is decentralized manufacturing. And the concept is that try and have limited assets. Ensure that you do your top line and get the bottom line, improve your revenue and profitability. And let's be also clear that the workforce composition model is something that is decided by the top management of a company and not by unions. And the present model is enterprise want people and not necessarily employees. And I'm drawing this distinction. I come from a generation where I started my career in 1970. There was no contract labor. There was only permanent, temporary, badli, and casual. In fact, there used to be ODR, one-day recruitment. I started my career with Mukund Iron and Steelworks Limited in the Kurla plant. And I tell you, started a career as a shift supervisor. We knew most of the workmen and called them out by the name from the gate. Now, this was a different employment model. That's not the employment model. IT systems were not there. So what has happened that companies have also restructured irrespective of the law. They found answers and have come with it. Yes, there is the phase that let's look in terms of new legislation, which has been looked at. Now, when you look at the present employment model of enterprises, people are designated as executive, but they necessarily may not be working as an executive. To a large extent, it is not my designation, but it's my work content. It's interesting, I was other day flying and taking Indigo flight. The lady at the gate says, I am the gate manager of Indigo. Now she can say, I'm the vice president gates of Indigo. In a picture hall, he's called a gatekeeper. I mean, on a railway station, he's called a station checker. Now, there is this fancy designation, and inflation of designation has been a concept that has been taking place, and most people are happy when you get inflated designation, because all said and done, as a youngster, inflated designation looks very impressive on your visiting card and also helps you with your matrimonial prospects because you look as a fancy designation. I come from a generation where I had old type designations as basically assistant engineer, charge hand, foreman, superintendent, and not the fancy designations of manager, general manager, vice president, president. I mean, there's a consulting business company, I don't want to name it. There are 32 managing directors. Every functional head of business is they call managing director. Now, the other is that minimum workers, permanent or temporary. The concept no more is to have permanent or temporary workmen or have minimum permanent. Most companies have done away with the temporary. Earlier, they would give the 240 days break, try and see which was a bad. It is maximum contract labor through contractors. And in fact, the reality is that companies have been taking bulk contract labor, and that is the business model today. There was this National Employment Enhancement Mission scheme that was started in 2013. It had to be discontinued because all said and done, the way employers went on misusing this, certain companies managed to get a stay order, but the government of India on 23rd December 2022 withdrew the scheme. because this became the employment model of a large number of companies in terms of taking people from 3 months to 3 years. They didn't get their provident fund and others, but yes, enterprises also find escape routes when laws do not suit them or how. There's something else that has also taken place, which is now prevalent in a lot of companies post 2014. The Apprenticeship Act was amended, optional trade was brought in, and there is merit in the optional trade because there are types of trades which cannot take place at the ITI, especially when you look at the automobile sector or you look at high technology areas. And this is the type of optional trade where companies also take their own. There has been liberal approach on the National Apprenticeship Promotion Scheme, NAPS trainees post-August 2016, where anywhere between 15 to 18% of your workforce you could take. There are certain states where it is permitted up to 25%. And this includes the contract labor. So this is the employment model that companies, I'm intentionally bringing this out because we need to look in terms of the labor laws, the industrial relations code, in context of the way business is being operated today. The business is not the way it was operated earlier, and the business model has drastically changed in this country, and enterprises are sharp. And I keep seeing enterprises, how they're working out their employment model. And you can clearly see that how temping companies in this country have grown. When you look at some of them are supplying as much as 400,000 people. In fact, when you look at certain companies, they're very big. And there are very big temping companies supplying you manpower, not only of contract labor, but even executives. So this is the new type of supply chain of manpower also taking. It's not the old time contractors giving you manpower. Now, when I look at the issues in enterprise, and if I correlate them with the amended labor laws that I want to look at, the way the codes have been modified, I want to look one at recognition of union and the trade union rivalry that takes place. Other is the types of employment. Third, I want to briefly cover up notice of change, because what has happened, Section 9A notice of change, which was there under the ID Act, has remained as it is under the IR code. The dispute settlement mechanism, how strikes and lockouts will become very tough. What is it in layoff, retrenchment and closure for the workmen, and why the unions are opposed? I will look at the compensation that they get and the type of contract labor, how this has been amended, because this is not in the IR code. The contract labor engagement has been put under the Occupational Safety, Health and Working Condition Code. Same is true with the gig and platform workers, which is the new methodology in terms of employing people. Now, when I look at recognition of union, it is interesting that when we look at recognition of trade unions, the Trade Union Act only talked about registration, and the Trade Union Act in India was silent on recognition. There was nothing specified that what is the methodology by which you will adopt recognition. There was what was called the Code of Discipline that was brought about by the Indian Labour Conference. Let me be honest, Code of Discipline hardly applies. So there are three methods by which you recognize a negotiating union. It can either be by the checkoff system, it can be by the secret ballot, or it can be by member verification. When I look at Section 14 of the IR code, it talks that even if a single union is formed, it will have to be recognized. The code is silent whether it will be the checkoff system, the secret ballot, or the verification. And hence, rules become important. I am intentionally bringing this out because, there are small and medium enterprises where you don't have union, employers did not recognize them. And what has happened, because the code is silent on a single union being recognized as a negotiating union, what they've done is that they have put down under the rules. Now, as far as the central government rules are concerned and the Punjab government rules are concerned, they are silent on what should be the amount of membership for a union if it is a single union. But when you look at the states of UP, Gujarat, Haryana, they are also silent. In fact, they say that a single a union that has been formed, but they don't specify whether it needs 10% membership or 20%. The IR code very clearly for the trade union lays down that if any union has more than 51% membership, it will become the sole bargaining agent. And it also says that if the company does not have a union with 51%, then any union that has more than 20% of the membership, they will become what is called the negotiating council. Now, when you want to look at membership, the check-off, secret ballot, and verification are three methods. The secret ballot by law is there already when you look in terms of the state legislation with reference to West Bengal, Kerala. In Maharashtra also you have MRTU Pulp Act, but it is not by the Labor Department. It is by the court. The Labor Court gives you the recognition. Now, what has happened when you look at the single union, the UP government, the UP, Gujarat and Haryana government are silent. Madhya Pradesh government says that if you have 20%, then you can be the sole bargaining agent. Bihar says if you have 25% as a single union, you can be. Karnataka, Tamil Nadu and Telangana say 30%. Kerala has put 1/3, that is 33.3. And Maharashtra and Rajasthan have put 51%. So in fact, a small union or a small union will not take place. Then comes the system that what should be member, how do you verify what percentage? Now there are three methods: check-off, secret ballot and verification. The Gujarat rules state that the check-off system will take place. Those of you who are in Maharashtra, and if you look in terms of the Bombay Industrialization Act, BIR Act clearly lays down check-off system, which is prevalent with the textiles as well as with the power companies, also the sugar mills. Now, as far as Rajasthan is concerned, it says that the employer will decide. Then what has happened is that the secret ballot has been mentioned by Tamil Nadu, UP and Karnataka, Kerala. The others have said member verification. When you look at the state of Maharashtra, what they have said is that they've said that the state government to decide. Now, what has happened? Unfortunately, this was left out in the Central Act and it is only there in the rules. So it is going to differ from state to state. Now, the second National Commission on Labour, when I look at the report of Mr. Ravin Verma, he very clearly had said that the check-off system be made compulsory in all units having more than 300 workmen and negotiating agent on basis of check-off. And he also said that the recognition be granted for 4 years and co-terminus with the period of settlement. I'm quoting the clauses in which his report, because at one stage I dealt with that report very closely. Now, this did not find place in the IR code. But yes, in all fairness, one of the major gains to the trade union under the IR code is that a union which is formed in an enterprise which did not have, it is not the employer that will have the choice to decide whether it will recognize or not. By law, the union will have to be recognized. And they can go to the Labor Commissioner's office and get it recognized. The methodology will differ from state to state. So this is a major benefit that the unions have got under the Act. And this is something that one must try and recognize. When I look in terms of the Employment Standing Orders Act, which is also part of the IR code. Now, the Industrial Employment Standing Orders Act, if one looks at it, was started and came in 1946. It was Shantilal Shah, who was then the Labour Minister, well-known solicitor in the interim government, and he had framed that, because large number of companies did not even have an appointment letter, and that's how he said that you have what is called Industrial Employment Standing Orders Act, which specified the types of employment, the punishments that can be given, and all the other items that came about under the industry. He also said, that companies can get their own certified standing orders if they have more than 100 workmen, or if they have less, the model standing orders will apply. What has happened? The threshold limit has been raised from 100 to 300 under the new code. At the same time, it says that if anybody had what was called a certified standing orders, they will remain. They will not become non-operational because their numbers have fallen less than 300. Now, what will really happen? Companies having less than 300 will have to bring their own employment rules. They may bring it in line with the Occupational Safety, Health and Working Condition Code or their own. Even till the date, this has not been implemented in any company having more than 100 employees. I would still suggest that please get certified standing orders. It will not take time. Do it. It is worthwhile. There's a major development under the industrial employment, the fixed term employment. And in fact, I must admit that a lot of employer organizations went on saying fixed term employment is good, fixed term employment. Please be clear, fixed term employment is the time period of contract is not specified, but it is not, the fixed term has not been introduced, which is aimed at employment, but it is due to a sudden demand of service. It's like a definition of the temporary workman, which was there under the earlier act itself of Industrial Employment Standing Orders Act. You perennially cannot keep on renewing the fixed term contract under the act. It will get into litigation. And my own perception is companies will still continue with the Contract Labor Act rather than entering into fixed term employment. Fixed term employment, yes, has given a benefit that the gratuity is payable beyond 1 year service and does not need a 5-year period. But fixed term employment has its own limitations. You must have a certain temporary increase in work or a certain order to justify it. Otherwise, this will lead to a lot of litigation. And let me tell you, companies entering into fixed term employment will help the unions to litigate, and lawyers will keep on having a field day. Please be cautious of using fixed term employment. And I'm making this very categorical in spite of the fact that when I interact in employer organizations, all of them plead, it's an excellent idea. It's not an excellent idea. Please be clear. It is only for a temporary increase in work. This was given earlier, if you recollect, fixed term employment was brought in when Mr. Sahib Singh Verma was the labor minister of the country. Mr. Atal Bihari Vajpayee was the prime minister, and then it had to be withdrawn when the Manmohan Singh government came to power. Later, fixed term employment was also brought in by Smriti Irani when she was the minister for textiles. This was also brought in by Arun Jaitley as the finance minister with reference to the central public sector undertaking. I have done certain analysis. Let me tell you, none of the PSUs use fixed term employment with reference to the workforce, though they have it. The only state where fixed term employment in rules is permitted is in the Gujarat state, where to some extent it is used, but is limited. Now, when you look in terms of the Second National Commission on Labour, and when I look at Industrial Employment Standing Orders Act, they also mentioned that, work to rule should be looked as a misconduct under standing orders, but yes, it has not found place, because what has happened, the items under standing orders that were there, the same have been taken and just copied, and there have been more a cut and paste job rather than looking minutely as these changes. Let me come to the other angle, which is notice of change. I'm intentionally bringing this out because Section 9A notice of change is under the 4th schedule. What has been done is the same thing has been copied under the IR code and put under the 3rd schedule, calling it under Section 40. In fact, item 11 of the 4th schedule says, and look at the wording, any increase or reduction other than casual in the number of persons employed or to be employed in any occupation or process or department not occasioned by circumstances over which employer. Now, any increase, please be clear, this item 11 they've taken from the 4th schedule is basically a copy from the BIR Act, because those days it was a piece rate system. In a piece rate system on a textile mill, if on a loom instead of 3 people, there are 4 people, then my earnings would fall. Today, you are not employing people on piece rate system. You are employing on time rate system. In fact, when you look at the Second National Commission on Labour report, because I recollect also discussing this at length with Mr. Ravin Verma when he was the chairman of the Second National Commission, he categorically in his report had said, delete this item. Do you realize nobody takes you to court because you give employment? We talk about generating employment. The IR code has just copied what was there in the Industrial Disputes Act. In fact, it is very unfortunate that these are not. I agree that no union will drag you to court when you do any increase in manpower. When you look at item 10, which is the most sensitive part, rationalization, standardization, or improvement of plant or technique which is likely to lead to retrenchment or workmen. This has been retained. Please be clear, technological development world over is aimed at reducing unit manufacturing cost, giving items of consistent quality that is meeting Six Sigma limits. At the same time, it is based on a premise that my energy consumption per ton of output falls on what is called green energy. If you want to remain competitive in business, you have to rationalize, standardize, and improve plant and machinery. Now, what happens is that Section 10 of the Schedule 4, which is now under third schedule of the IR Act, has been kept as it is. I have in my career faced a lot of litigation on this. Now, as an escape route, most of us, what we do is, while signing the long-term settlement, try to overcome this clause and get away. But please be clear, if the country has to progress and industry has to progress, please be clear, you have to bring in new technology. Are we not aware that how computers were opposed by Voltas at one time in this country? The Voltas union dragged them. I was a student of Jamnalal Bajaj Institute. I recollect that the computer lied in the dock for 6 months. Technological development have to take place, and this item should have been removed. Now, somehow or the other, it continues. And yes, this is an advantage for trade unions when they want to use it against a management. And yes, this is something that has been continued in the IR code, which is unfortunate. Now, let me also come to, they have looked at works committee. They have also looked at grievance committee. Works committee is something that was brought about by the Tata Steel, which was TISCO. It was incorporated under the ID Act. Normally, the items that come up in the works committee are not of conflicts, and basically there are some items that come up on ventilation, sanitation, water, restroom cleanliness, sitting. So it's not going to solve out. Yes, it is there and will remain. It is part of the IR code. But what I see is that they have brought in the grievance redressal committee, and I want to bring this out. Section 4 of the IR code is none other than a copy of this section that was brought in 2010, an amendment that companies needed to have a grievance redressal mechanism. The number that was first confined to 6, the limit has been raised from 6 to 10. But what is needed, while the code has done an excellent job of giving commonality of definitions in each of the items so that there is a uniformity in thinking in terms of wages and others. But when you look at grievances, because you're looking at grievances that are unresolved, are to become disputes and go in the labor commissioner's office. And there is no definition of grievance. See, one of the most important items when you look in terms of the labor laws, or we look at the code, is Section 2, which defines a word. And every word that is defined needs to be read and interpreted, because that is the definition and not the Oxford Dictionary. I have myself made an effort to define it here, and I want to deal with it. Grievance is any discontent or dissatisfaction or suffering or grief or wrong or hardship that an employee, I'm using the word, thinks, believes, perceives, or feels to be unfair, unjust, or inequitable, whether valid or not, arising out of anything connected with the company, and through a communication brings it to the notice of the company management. Now, why I'm trying to say is that, when you look at this, giving the fillip for the grievances that are not resolved, and having the rotationship of the chairman and the vice chairman between the management and the workmen, equal representation, and finally, the grievance by the individual or his union can be taken for conciliation to the conciliation officer. The definition of grievance should have been there. Unfortunately, it is absent. I just wanted to bring that out. The existing process continues of the conciliation officer. They brought in the industrial tribunal. All said and done, what has happened, why unions adopt direct action, is because resolving disputes through conciliation officer and industrial tribunal, or if it goes into court, please be clear, it takes 4 to 5 years before an award comes. The conciliation officer has no mandatory powers. he or she can only give a failure report, and that continues. And let me tell you, the dispute resolution mechanism by and large remains the same, except that you have brought a bureaucrat as a member rather than the independent judiciary, but that's okay, a change that has taken place. But otherwise, the conciliation proceedings remain what they are, they will continue, and they will be there. What tends to happen is unions basically want immediate action, and that's why it leads to agitation or confrontation and trying to resolve the disputes. I must also admit that most managements also do not want to go into lockouts and others and try to resolve it out. Now, let's look in terms of something called prohibition of strikes and lockouts. Section 62 of the IR code makes it mandatory for 14-day strike notice. Let me tell you, earlier this applied to what was called essential services. The definition of essential services has been removed from the code. So they have made it applicable to all enterprises. And this is something which the unions are up in arms against the government, because what will happen, a strike or lockout will become illegal if you don't give the 14 days notice. And once it becomes illegal, I want to come to another angle which the employers will gain. When you look at the wage code, because Payment of Wages Act has been merged in the wage code, in the wage code, what has happened earlier, Payment of Wages Act is applicable only to those people whose monthly wage is less than 24,000 rupees. Having removed the wage code by the definition of 24,000, it has been made applicable to workmen, executives, and the whole lot. Now, what happens if any workmen go on strike? The employer can put up a notice and deduct 8 days' wages. Let me tell you, it's a boon to employers. And I'm speaking this with practical example. I was advising a company in South. It's an MNC that was there, private held foreign equity company. Every year in the wage settlement, there would be agitation and other things. Earlier, they did not have a union got formed. Then there would be some 1 day, 2 day stoppage. Then they'll say that we'll work next time. I was advising them, I said, put up a notice, because when I looked at the wage, I saw all the union leaders' wages were above 24,000 and 50% of the wages of the workmen were below 24,000. So I said, put up this notice and deduct the 8 days' wages. They went into conciliation, they lost it in conciliation. Conciliation officer went on saying, give it. The law clearly permits you to deduct wages if they under the Payment of Wages Act. Now, it is true that there was a ceiling in the applicability of the payment. Now, what has happened when the Payment of Wages Act in the wage code has been copied? They have made it applicable by removing 24,000. So, this is a major advantage to employers. I also want to mention that the Second National Commission on Labour had said that whenever a strike takes place, there should be a strike ballot. The MRQ Pulp Act lays that down, but not every act lays that down, which must be supported by 51%, and the lockout will require the highest level, which is at the board level, and approval. Now, none of this have been taken. What has happened is that the lockout and strike 14-day notice, by removing essential services, they made everything mandatory to go to the labor. And this is something on which the unions are up in arm against the government, and the government is finding it tough to implement, because this is a point of contention, which a lot of unions realize, because quite often I recollect when George Fernandes became the industries minister, he went on very jokingly saying, there is no legal strike, there are only illegal strikes. Don't forget, he was the one that organized the famous railwayman strike in 1970. He later did become the industries minister and then also the defense minister of the country. A very powerful trade union leader of Bombay. I, as a student, saw what he was doing, and very powerful in the Bombay Municipal Corporation, where he dealt with. So yes, strikes and lockouts will take place. They may not follow this. And when you make them illegal and you give this as an edge to the employers, obviously the unions are going to be up. But I also see this as an advantage to the employers by removing the code. And I myself used it to my advantage in a particular case. The other part is layoff, retrenchment, and closure. The threshold limit was 100, which has been revised to 300. This is something which is there in Section 77 of the IR Code. The Second National Commission on Labor had mentioned this. In layoff, yes, people get half the wages, but with reference to retrenchment and closure, what has happened while the limits were revised from 100 to 300, which is the major change in the IR code, the compensation amount have been retained as the same, except that 1 month salary has been given under skill development. Now, why I'm trying to bring this out, that the Second National Commission on Labor clearly had laid down higher compensation when they suggested retrenchment and closure, the threshold limits to be revised. The compensation was 45 days wages per year of service for sick industry, with a view to make it viable, and with reference to 60 days wages per year of profit making, and for establishing and employing less than 100 workers, the compensation would be half the amount. Now, when you look in terms of it, what has happened, the IR code in parts has taken things from the Second National Commission on Labor report, and quite a few things it has just missed out. I mean, if you are giving increase in terms of the threshold limit from 100 to 300, in all fairness, one should also look at increased compensation to the workman. And why not? Half-month compensation per year of service is not much of compensation. Let's be clear. Even if you look at the VRS schemes that company launched, or you look at the Gujarat model, or if I even look at the Income Tax Act that gives you exemption up to 5 lakhs of rupees to get your schemes, to conform under the Income Tax Act, it says that, the compensation amount paid to the departed employee should be not more than 3 months' salary per year of service, subject to a limit of the maximum number of years of service, subject to a limit of 5 lakhs, which will be tax-free. The same model was also used in terms of what is called the Gujarat model, which was used by the government itself to give VRSs. Now, reality is that companies have to restructure. Companies do go through bad patches. At the same time, workmen need to get a fair deal. Now, when you raise a threshold limit from 100 to 300, though I must admit that certain state governments have already raised the limit from 100 to 300 that were BJP-ruled states. The reality is that this is going to be a bone of contention in quite a few states, more so when I see in states like West Bengal as well as Kerala and some other states. They are not going to at all agree to this limit. And the compensation amount, though I must admit that the government now is thinking of speaking about minimum wage to a fair wage and all those things. Yes, that will take time, but this is what one needs to look at, that when one looks at the retrenchment compensation, I must say that the changes in the law, in the code as passed by Parliament, have done not a full justice when you look at it in terms. Now, compensation for closure, that said 30 days for per year sick units and 45 days for. When you look at the contract labor, because contract labor has become another major methodology of employment by most companies, and there are a large number of companies in the service sector. If I look in terms of ICICI Bank, I look at Kotak Mahindra Bank, I look in terms of Axis Bank, everybody is a Taiwala executive. It is not like the nationalized banks where you have clerical staff, the account, the cashier is bargainable. They have all people that are executives, or there is back offices and contract labor. Now, one of the major changes in the occupational safety and wealth, which has looked at contract labor, they've said contract labor is not permitted in core activity, but only permitted in non-core activities, and they've defined it. I must also admit that, Chandrababu Naidu, as the Chief Minister of Andhra Pradesh, was the first one that brought about a change in the Contract Labor Act rules of the undivided Andhra Pradesh, where contract labor could only be taken with reference to non-core activities, and the state government defined non-core activities. The same have been copied and put under this. The other shift that has taken place, and this is a major shift, I can tell you, Contract Labor Act was not applicable to EPZs and SEZs under the Contract Labor Act. This clause has been deleted, when you look at the Occupational Safety, Health and Working Condition Code. So all special economic zones and export processing zones to a large extent came under the collector, customs and excise. So it is very different. But even the special economic zones, which I've seen near Baramati that are there when I've looked at the factories of Cummins and others, let's be clear that, contract labor can be openly taken and they were not governed by it. But that will go away. The second National Commission on Labor had suggested contract labor not to be engaged in core production. But they had also said contract labor to be remunerated at the rate of regular labor. Now, contract labor has become a cost arbitrage for most companies. They have basically looked at this as reducing cost because contract labor to a large extent is paid the minimum wage and not a higher wage. I must admit some companies have been innovative that they give certain allowances. Some of the PSUs have done it and tried to give because contract labor is permanently there with them. They do have the bidding contract or what is called the L1 contract, but it is laid down that the new contractor will retain the same manpower because otherwise it creates what is called IR problem. Now, when you look at contract labor not permitted in, but with some exemptions, and this is interesting because these exemptions will really give escape routes. The principal employer may engage contract labor through a contractor to any if the nominal functioning of the establishment is such that the activity is ordinarily done through a contractor. If I have a greenfield site, I just take contract labor, I don't have permanent. So this function is normally done by contract labor. Or the activity that they do not require full-time, which means part-time employees, or any sudden increase of volume. I clearly see the first part as an escape route for large number of companies in greenfield site. So yes, I know that contract labor is heavily prevalent, but large number of companies, when this codes become operative, please be clear, relook at where you are engaging your contract labor. Let me be honest, large number of companies are engaging contract labor in core activities. I don't want to name them. I've been a manufacturing man, and let me tell you, I've visited companies and I tell them very clearly, the writings on the wall are clear. And please be clear, unions will drag you to court. Some of them will use social media and record it and also show you. You cannot continue to use contract labor on core activities unless you have done this as a normal function, which the escape route is there under the law. They have clearly said where contract labor can be engaged: sanitation work, watch and ward, canteen, loading and unloading, running of hospitals, courier service. I agree, large number of companies manage to get a permission from the Labor Department. Labor Department is equally liberal in granting permission on engagement of contract labor. But to a large extent, what is written and practiced are two different things. And please be clear, this is where companies will become vulnerable because the way they have been misusing contract labor, please be prepared, unions will take this up in a big way. Civil and other construction, gardening, housekeeping, transport, any activity of intermittent nature. Now, having completed the contract labor, and it is 5 minutes to 4, I just want to move on the last part, which is gig and platform workers. If some of you recollect, Mr. Piyush Goyal, the Commerce Minister itself made a recent statement, though he did some backtracking, that yes, this type of jobs that are coming are also creating problems for the pop and mom show. Now, what has happened? The Social Security Code has defined gig and platform workers, means a person undertaking who performs work or participates in a work arrangement and earns from such activities outside of traditional employer-employee relationship. They have used the conscious word employer-employee relationship. It's a fuzzy relationship. There have been agitation. There will be disputes. You will clearly see heavy unionization in this area because please be clear, unions are not going to also close shop. They have to remain, and unions are part of every political party in this country, irrespective of whether it is the central parties or the state parties. And let me tell you, all of them, whether they are in the ruling party or in the opposition, they want to have a trade union wing and they'll continue to have. And this is going to be the period, contract labor as well as the gig and platform workmen, where bulk of the unionization will take place. It is true that when you look at the platforms, they all operate through an algorithm which is secretive. It is not made known. There have been litigations abroad. The French court has held the platform and gig workers as employees because what they said is that the business partner should be managing the client himself or herself. The business partner should be in a position to set the price, and the business partner should choose how to execute the task. Now, all these three flexibilities are not there with reference to the gig and platform worker. I mean, please be clear. It is the company that decides where you go and deliver, how much you are paid. You are paid per trip. What is the bonus clause? How you are switched off. Now, obviously, I see litigations taking place in this, though presently, as the law stands, there is no employer-employee relationship. And when the court comes in, the court very specifically in section 235 and 261 of the Social Security Code defines it as a non-employer-employee relation. And hence, employers will use that to fight it out. Now, when I look at this, and clearly, while concluding, I want to conclude, the business model of the companies is apprentices, NAPS trainees, NEEMS trainees is by and large out, contract workers being paid minimum wages along with negligible security of employment is bound to have certain IR issues. And I'm bringing this up because there are companies where this type of workforce is as much as 4 or 5 times. I have been a manufacturing man, and let me tell you, all this cannot be loading and unloading. I don't know how many of you remember, I wrote a feature article on what I wrote as Apple falls on Wistron. And this happened on a Saturday morning on 12 December 2020. Apple is the American company for which most of us use a mobile, which is very expensive. The Taiwanese company Wistron was running this. It had only less than 1,000 permanent workmen and 9,000 contract workmen. And then they were paying them single overtime. This was under the Atmanirbhar Bharat, the productivity linked incentive scheme. When this took place, I must tell you, this occurred on a Saturday, 12 December. I have at least 3 colleagues of mine that sent me video recording of what happened that day within 4 hours. Obviously, some people inside the plant recorded it. Everybody went into damage control. I don't want to mention, there are 4 leading manpower suppliers that were supplying all this manpower. The company has now, the Taiwanese have withdrawn. Tatas have taken over that company. But please be clear, if that be your employment model, you are going to have problems, union or no union. With this, I want to conclude. The time exactly is 4 o'clock. I'm sorry that I have overshot the time. But please feel free to raise questions.
No, ठीक है?
How do you want to go about in question?
Sir, we can give 5 minutes for question and answer session.
Yes,
Maybe
yes, by
I know
all
it's
means, we
very
can
less.
take 5-10 minutes.
Okay, fine, 10 minutes.
I see you have 246 participants.
Yeah, it exceeded more than that.
Okay. Any questions? Any clarifications? You can also write to me. I will clarify. No problem. I presume everybody is on silence mode, so they can't speak. I'm just going through the comments. Somebody has written no sound, no audio sometime. Any clarifications? Anybody? Yeah, I can see Pranita Ingle.
Pranita, we are doing that unmute for everyone. Just a moment.
Hello, am I audible? Good evening.
Yes,
It's audible.
You're
Yes,
audible.
sir. Sir, thank you for the valuable insights. My question is that up to what extent it is possible that the labor policies of the government of India can be challenged in the International Labour Organization?
See, there is what is called a credential committee. It is not labor policies, but it is practices. If you have a point of view, there are people that have challenged. It was once done when Jayalalitha was the chief minister and the teachers had gone on strike and she had dismissed them. Now, if you look in terms of the Industrial Disputes Act, it is not applicable to government servants because they cannot be retrenched. So this was a complaint filed. It went to the Credentials Committee, but it was lost out. There are unions that have taken up on issues that they go to the ILO Credentials Committee, but there's a process by it. See, it's not a labor court. See, what happens is that the countries under the ILO, there are conventions, and only if a country ratifies a convention, then the country is liable for that convention. So it is not the labor laws that you can challenge.
Okay, thank you, sir.
Because every country is sovereign.
Okay, thank you.
Sir, good afternoon and good evening.
Good
Sorry.
evening.
Sir, I have one question with respect to the union. The number increase from now 7 to 300. What of the existing union recognition and their process?
See, you need a minimum 7 people to form a union. That is as far as the Trade Union Act is concerned. But you need 100 or 10% in that enterprise to register. It is not 300. It is 100 or 10%. So there will be multiplicity of unions. That's the law of the land.
Hello, sir. Good
Thank
evening.
you.
This is Vijay. Yeah. Good evening, sir. This is
Yes,
Vijay.
Vijay.
Session was very nice. So I just want to ask you by when these codes will be implemented, and in this light, do we need to restructure our salary structure components to
See,
just
most
comply?
companies, as far as the codes to be implemented, it is likely that they should be by beginning of next year. This is my perception. But there can always be a slip between the cup and the lip. I mean, I don't work in the government, so I don't know when the labor minister or the government in power decides to come out with the gazette notification. But as far as wage code is concerned, wage code was passed in 2019. And for the first time, wage code has defined what is wage, that is basic plus DA, has to be at least 50% of the definition of remuneration. If it is not, 50% of the monthly remuneration is taken as basic wage, basic plus DA as the definition of wage with reference to calculation of gratuity, leave encashment, and PF. So a lot of companies have restructured their wage. I did not get into that area because at one stage, NHRD network, Mumbai chapter had done a full-fledged program on the wage code.
All right, sir. Thank you so much.
Regarding standing orders, you mentioned that only certified standing orders would continue, and
No,
that
the
is how.
model standing orders will apply to people that are more than 300.
So if the number is less than 300, we need to get
You will
to
have to
have
look
certified
at
standing
your
orders.
own one something. You'll have to come with service rule because the model standing orders do not become applicable unless you have a certified standing order.
Thank you.
I did mention if anybody has more than 100, there's still time to get certified standing orders done. It takes some 6 weeks, but you can easily get it done.
So good evening, sir. This is Ashish Sharma from Gurgaon. I would like to understand that post implementation of the labor code, so we have to standardize the wages, right, sir? So in that case, the gratuity and the other things basically it attract more compliances. So in the existing CTC structure, the people take home will be on the lesser side. How basically we prepare our salary structure in
It
that
all
case?
depends upon what your salary structure is. It's a session by itself because what is it that you are giving in CTC? There are items that can be included that cannot be included. You can't show your gratuity contribution as part of CTC. It is not permitted under the definition of the wage code for calculating remuneration. The real problem will come in the PF gratuity and leave encashment and the overtime calculation for workmen. One has to rework out the salary of the enterprise. See, what has happened, large number of companies have tried to give items which did not cover up PF and DNS allowance. So that they took that low amount of basic and DA in certain cases to as much as 30% of the CTC. That is not going to be valid. And a lot of companies, I must admit, have restructured their basic with their annual increment. See, the wage code was passed in 2019. You had 1st April of 2020 right up to 1st April of 2024. 5 years have passed. You should have looked at it.
Hello, good afternoon, sir.
Good afternoon, Pranita.
Sir, I'm pursuing my MBA in HR. So, sir, my question is that is there any grievance redressal mechanism for the gig workers?
As far as the gig code is not specifying it as yet.
So, sir, so as a HR profession, how to mitigate that challenge as a HR profession? So, if we are not able to address this,
As a company, you can have a grievance procedure. Nothing prevents you from doing it. Because see, what has happened presently, gig and platform are defined as a non-employer-employee relationship.
yes.
But see, there are grievances. Suppose if they go on strike, you will have problems. So look at a grievance redressal mechanism. Nothing prevents it. As a company, you can bring it out. I have seen a particular company, if I'm not mistaken, this was Tata Chemicals, where they had a grievance redressal mechanism which also covered up contract labor as well as the people in the site near their plant.
Okay.
Sir, this is Satish Nair.
Yes, Satish.
Yeah, sir, my question is related to PF contribution. See, basically, the definitions say that, okay, the 12% of basic plus DA to be deducted, either the basic to be deducted for the PF contribution. But still, I observe that many companies are restricting the amount to 1800 or the threshold limit of 15,000 deduction from the employee side and employee side. Is that
It is permitted by
exercise
law.
or practice is good?
I'm not saying good or bad. There are companies that have limited it to 15,000 because there are a lot of youngsters that believe cash is king and they want it in hand. Just listen to me. What really happens is that as far as the PF Act is concerned, the limit of 15,000 when you start in a new enterprise is possible. But if you are paying on the total basic and DA in old companies, then you can't bring it down to 15,000. That is not permitted. But in greenfield sites, there are lots of companies where the PF is confined to only 12% of 15,000. There is a move. It is likely that this figure of 15,000 will be revised to 21,000. There's a move that recently has come in the media, which is being looked by because the PF department has sent such a proposal to the PM office.
But see, my point also that, okay, if we restricting apart from the industry practice,
it is for every employer to decide.
Yeah, so from PF point, there is PF department, there is no objection from by doing this.
PF department has no objection. That's what the law is.
Okay, thank you, sir.
Good evening, sir. Shubhajit here.
Good evening.
Sir, my question is for this FTC, fixed term employment in a contract basis. So when this rule comes into existence, it will be if effective retrospectively or from the
So it
future
will be
dates.
prospective. See, it cannot be retrospect, because what happens is fixed term employment was also permitted under the ID Act. And in project, people used to do this.
Okay.
But Masgao Docks, to a large extent on frigates, has done this and managed to win a court case in Bombay High Court with reference to welders.
Okay.
Sir, I am Ivy Singh from OBT. I have two questions, actually valid question. One is one of our buyer is asking to provide ESI and PF to our apprenticeship workers, which is, although we have given all interpretation that Act doesn't say that the apprentices are required to pay PF and ESI, but they are pressing us hard. What is your opinion for this, sir?
You sort out with your buyer, you have to do business.
Actually, as per law, it is not
See,
applicable.
Yeah, but see, there are also, I'll tell you, there are small scale enterprises where the ESI Act does not apply because of their numbers. But there are big time contractors that don't, bigger engineering companies don't give contracts to such people saying nothing doing. If you don't comply, we'll not give you business.
They are actually government.
I know somebody who was doing business with Larsen Toubro, and Larsen Toubro made it very clear. We are not interested in such small type suppliers that do not do this.
Okay. Second question is, this is...
Look in terms of a buyer, you have to do business.
Okay. New budget, under new budget, there are some incentive scheme for new entrants under employment. What is the expectation? Why this will come?
Let us see when it becomes operational now. I can't make a statement.
Okay, sir. Thank you very much. Thank you very much.
Good afternoon, sir.
Sir,
I think this should be the last question. It is time is 4:15.
Good afternoon. Good afternoon.
Yeah.
Am I audible? Sir, right now we have employed some contractor for work, but after implementation of new wage code, new IR code, just like right now, if they bring a contract labor from 4 states, they have to take license from all those 4 states. But after implementation of this code, they have to bring only one license.
That is correct.
So what are the mandatory forms, register or licenses that we need to check after
They are given in the
implementation?
rules, The acts don't specify that. The forms are all given in the rules. You can look at it.
Okay, sir. Sir, can you please share one website link or from where we can refer that?
No. At the state government, look at an act. The rules are there.
Okay, sir. Okay, sir.
I
Thank you,
think time is now 4:15.
Hello, sir. Can you have a last question?
Yeah, Tushar, last question.
Sorry, actually, currently we are facing genuine issues, sir. Actually, currently the practice is, employer is taking mostly naps and through major workforce through the contractors. Okay, so how we can look at after implementation of new wage code to have this employability to convert or migrate from this NAPS or contractual workers to fixed term employment? Which will be the...
Let's be clear, NAPS is a certain percentage of your population.
Yes.
Contract labor is what you have chosen and got permissions. So that is your employment model.
Yeah.
So you decide what your employment model is. It's purely, see, let me tell you, the employment model is a top management decision. And I'm making a statement that this is mainly a cost arbitrage model by large companies. And for this, you also need to be prepared for IR repercussions.
Yeah, to refrain from these IR issues, which will be the best?
Yeah, but best way is, you don't want to have any permanent workmen.
Yes, but very less actually.
No, but you need to decide, would you like to be a contract employee yourself?
No, obviously.
Why?
Yeah, very
Similarly,
less.
think of it about the other. So they are bound to unionize.
Yes, yes.
At some stage, see what has happened. That's why I gave you the example of Strong.
Yeah.
When you use it to this extent, it is bound to backlash.
Thank you, sir.
Okay.
With this, thank you so much, Rajan sir, for your insightful session. And I'm sure it will help all our participants to all the HR professionals in their organization. And we look forward to have such more sessions with you in the future, sir. And I would like to thank all the audience for making this session very interactive and very interesting. Thank you so much once again.
Thank you.
We
Thank
will
you.
end the session. Yeah.
Okay.
Thank you, Rajan sir. Thank you.
Thank you. Thank you.
I would like all the participants to fill the feedback form. I have already shared in the chat box. So please just take some time and you can fill the feedback form and share with
Thank you,
us.
Rajan. See you.
Thank you, Rajan sir. All the best.
Thank you.
Thanks a lot.
Thank you.
Thank you, sir.
Thank you. Thank you.
Thank you, sir.
Thanks a lot.
Thank you, sir. Thank you.
Thanks.
Thank you, sir.
Thank you.
Thank you, sir.
Thank you. Thank you.